This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, Ms. Conine. Is that the way you pronounce your name?
It is. Thank you, Your Honor.
And Mr. Pratt. Both of you are welcome to the Tennessee Court of Appeals. Your panel this afternoon will be Judge Frison, Judge Davis, and myself, Judge McClarity. We will proceed as if we were in court on this matter, except you will not have to stand and rise. You can present your case sitting down as you are. Also, I assume that the times restraints has already been imposed. Ms. Conine, have you reserved your time for rebuttal?
I have, Your Honor. May it please the court 3 minutes, please?
Okay. Okay, then. Are there any preliminary matters, Mr. Clerk?
No, Your Honor.
Then will you please call this case?
Jessica Meeks Conine et al. Versus Medtronic Sofamor Danek USA, Inc.
Ms. Conine, the court will hear you.
Good afternoon, Your Honors. May it please the court, I am Jessica Meeks Conine, appellant in this case. This case is before the court on appeal from the Davidson County Circuit Court's dismissal of appellant's claim for damages. This court should reverse the Circuit Court's dismissal for 3 reasons. First, appellant's original lawsuit was filed in federal court. As appellee pointed out, that court lacked subject matter jurisdiction. A federal court cannot enter an order affecting plaintiff's substantive rights when it lacks subject matter jurisdiction. Second, since the federal court lacked subject matter jurisdiction, that court's order should not be considered a non-suit for purposes of the Tennessee Savings Statute. And finally, Tennessee Code Annotated 28-1-115 allows a plaintiff 1 year to refile in state court when a federal case is dismissed for lack of subject matter jurisdiction. That statute, in conjunction with the Tennessee Savings Statute, makes appellant's most recent lawsuit timely and proper. The procedural history is before this court, but I'll present a brief synopsis. Appellant's original injury date is 6/24 of 2015. Appellant filed in federal court on June 1st of 2016. That case ended on 8/12 of 16, and appellant's first circuit court complaint was filed on 10/31 of 16. An agreed order of non-suit was entered in March of 2019, in which the parties agreed that any successor action would be filed in that court and assigned to that undersigned judge. Appellant filed her complaint as contemplated in that non-suit on July 24 of 2019. The appellee filed a motion to dismiss, and the circuit court granted it. It is from that dismissal that I seek this court's review. To my first point, as we know, federal court may exercise original jurisdiction through diversity or federal question. Appellant's original lawsuit lacked both diversity of citizenship and question of federal law. Since the federal court lacked subject matter jurisdiction, the court was unable to substantively affect appellant's rights.
Counsel, let me ask you a question on that issue. Is it correct that in federal court, that court did not reach a decision on jurisdiction? It merely brought up the issue and invited briefing, and prior to that, you made the decision to voluntarily dismiss that case. Is that correct?
That is correct, Your Honor. The court sua sponte addressed subject matter jurisdiction, invited the parties to brief it, and counsel for appellant filed a motion for voluntary non-suit, and a voluntary non-suit was entered by that district court.
Thank you.
Since the federal district court lacked subject matter jurisdiction, the court had 2 options: to transfer to a court with proper jurisdiction or dismiss for lack of subject matter jurisdiction. To my second point, since the federal district court could not enter an order of non-suit, the order of the district court did not trigger the appellant's savings statute. In Cooper v. Glasser, the plaintiff filed a lawsuit in California state court. The defendant moved to dismiss. There was a dispute over a forum selection clause, and the plaintiff voluntarily dismissed his case without prejudice. Less than 2 months later, plaintiff filed against the defendants in the Federal District Court in Middle District of Tennessee. The defendant again moved to dismiss, and plaintiff again filed a notice of voluntary non-suit. The plaintiff refiled his lawsuit for the third time, 13 months, if the record is clear to me, after his voluntary dismissal in California, in the Circuit Court of Davidson County in Tennessee, and the defendant moved for summary judgment. The court granted the defendant's motion, and the plaintiff appealed. In reversing the trial court's grant of summary judgment, the Supreme Court held that Tennessee's claim preclusion law determines the effect of a federal court's judgment following a voluntary dismissal. Tennessee law does not preclude plaintiff from maintaining the present action in the Circuit Court for Davidson County. To my last point, Tennessee Code Annotated 281115 allows a plaintiff 1 year to refile in state court when a federal case is dismissed for lack of subject matter jurisdiction. My first lawsuit lacked subject matter jurisdiction, and since the court could not enter judgment on the case it lacked jurisdiction over, I had 1 year to refile in state court and did so. It is from that First Circuit Court case that my non-suit should trigger that Tennessee savings statute. And it is from that point that I had 1 year to file my last lawsuit, and I did. I filed my most recent lawsuit within the year contemplated by the savings statute. It is for these reasons that I have asked the court to reverse and remand my case for further proceedings. Unless there are any further questions from the court, that concludes my argument.
I do not hear any. Okay.
Thank you.
Okay, you do have your time for rebuttal. Mr. Pratt, the court will hear you now. And I think you have your mute.
I just fixed that. Thank you, Your Honor. Can you hear me now?
We can hear you now.
My apologies. Good afternoon, Your Honors. It's a privilege to be before you today. My name is Brian Pratt, and I represent Medtronic. May it please the court. Plaintiff has been represented by counsel in all of her lawsuits and is herself a lawyer, and has been given every opportunity by the courts to pursue her claim, but she never did. This case is a straightforward application of the Tennessee savings statute, and Medtronic respectfully requests this court affirm the trial court's judgment, finding this lawsuit was barred by the statute of limitations and does not fall within the savings statute. Go back and talk for a second about the facts of the case. This case involves Ms. Conine's spine surgery all the way back in November of 2014. And in that surgery, it was a surgery to fuse plaintiff's L5 to S1 bones together. And that was to help hopefully fuse those bones together to help alleviate her very, very serious back pain. To help, what the surgeon did is he used Medtronic rods and screws. Now, these rods and screws are temporary, and they're designed to help stabilize the spine to allow those bones to fuse together. And that's the goal. The goal is for those bones to fuse together. If the bones don't fuse together, however, and plaintiff's bones did not fuse together, then the rods or screws can eventually break. And that's according to the instructions for use. By June 24th of 2015, plaintiff's bones had not fused together. And as a result, 2 screws broke. Plaintiff's injuries were discovered, and plaintiff claims her cause of action accrued on that date, and we agree. Plaintiff filed her first lawsuit in federal court in the Western District of Tennessee. It's the only lawsuit that plaintiff filed within the statute of limitations, and that's an important fact. Thereafter, Medtronic filed an answer. Plaintiff, therefore, after that, filed a motion for voluntary dismissal without prejudice. The federal court granted the plaintiff's motion and dismissed that lawsuit on August 31 of 2016. Now, the saving statute here is very clear. Plaintiff had 1 year from that date to file her new lawsuit. So August 31st of 2016 to August 31st of 2017. But this case was filed July 24th, 2019, after the statute of limitation expired, in nearly 3 years after the federal court dismissal, the 1-year saving statute extension had expired nearly 2 years earlier. So Medtronic moved to dismiss. The trial court then granted that motion and dismissed this case as barred by the statute of limitations and not saved by the saving statute. The issue before the court is straightforward, and is whether the saving statute applies. The record demonstrates it does not. There are a lot of facts and there are a lot of dates relevant to this case, and for the court's convenience, Medtronic has a chart of some of the relevant dates on page 9 of Medtronic's brief, and that may help orient the court to the dates. To be clear at the outset, the 1-year statute of limitations has run on plaintiff's claims, and that's undisputed. Plaintiff claims her federal court case should not be counted under the saving statute. But whether or not the court counts the federal case, the result is the same. This case is not saved by the saving statute. To be clear, plaintiff's case should absolutely be counted for the purpose of the saving statute. The plain language of the saving statute demonstrates that it should be counted. The saving statute, the Tennessee saving statute, is triggered when an action is, quote, commenced. It's the first sentence in TCA 28-1-105. Here, plaintiff commenced the federal court case when the complaint was filed in federal court. That act triggered the Tennessee saving statute and establishes plaintiff's federal court case counts. In addition, federal lawsuits have the same effect as state lawsuits. That was addressed in the Rector versus Daco Inc. case, where the court stated that Tennessee law is not, quote, intended to permit persons who file their initial complaint in federal court to have greater relief from the statutes of limitations than persons who file their initial complaint in state court, end quote. That's at page 4. Under the plain language of the saving statute and Tennessee case law, plaintiff's federal court case counts for purposes of the Tennessee saving statute. The court dismissed plaintiff's federal case on August 31, 2016. Plaintiff's lawyers filed this case July 24, 2019, nearly 3 years later. And that's the reason why the trial court dismissed this case and found it does not fall within the saving statute. Now we'll flip to the other side of the coin. If the plaintiff gets her wish and the federal court case is not counted, the result is the same. Because if the federal lawsuit is ignored, then plaintiff never filed any lawsuit within the statute of limitations. Plaintiff's claim accrued June 24th, 2015, and again, this case was filed in 2019, over 4 years later, and well past the statute of limitations. But plaintiff claims this case was filed within 1 year of her dismissal of her second lawsuit. But her second lawsuit was filed after the statute of limitations expired, and that's significant because the Tennessee saving statute only applies to timely filed lawsuits. And that makes sense because you can't use the saving statute to get around the statute of limitations. As a result, plaintiff cannot use the second lawsuit as a dismissed action to trigger the 1 year extension under the saving statute. In the Venerable Reed versus Cincinnati NO and TP Railway Company, a Tennessee Supreme Court case, the court stated the saving statute requires, quote, that the new or any subsequent suit must be instituted within 1 year after the termination of the action that was brought within the time limited by the statute of limitations. The Sixth Circuit recently came to the same conclusion in Knight versus Ram Nationwide Inc. There the court said very specifically, quote, the case sub judice was not brought within 1 year of the dismissal of the original suit, which was the only suit filed within the 1 year statute of limitations provided by section 28.3.104. Hence, under Reed, the instant suit was not timely filed, end quote. The dismissed suit must have been filed within the statute of limitations to trigger the saving statute. Plaintiff's second lawsuit was not filed within that statute, and under Reed and Knight and the Tennessee saving statute, it cannot trigger. So whether the court counts or doesn't count the federal court lawsuit, the result is the same. The case is untimely and not saved by the saving statute. Plaintiff brief also makes a stacking argument. Plaintiff's saving statute stacking argument has been repeatedly rejected by Tennessee courts, that you get a year after each dismissal. In Rector versus Daco, the court stated, quote, Tennessee courts have consistently declined to construe TCA 28-105A to permit plaintiffs to evade statutes of limitations by filing endless successive complaints involving the same cause of action simply because each later complaint was filed within 1 year after the dismissal of the preceding complaint. That's at page 3. Tennessee law and cases have long held that you can't stack dismissals after each dismissal. For that reason, again, the court should reject the stacking argument and affirm the trial court's judgment. Plaintiff's brief also addresses Rule 41.01, but Rule 41.1 is not relevant to the appeal simply because the trial court did not dismiss the case under Rule 41.01. As the court is aware, Rule 41 is a procedural rule, and that allows plaintiffs to take 2 non-suits or voluntary dismissals and refile the action a third time. The trial court's judgment in this case never mentioned Rule 41.01 because it dismissed plaintiff's case because it was barred by the statute and not saved within the saving statute. But plaintiff's briefing claims Rule 41.01 allows additional time to file this case, but that's not true. This exact issue was addressed in Payne versus Matthews. There, the court stated, quote, the issue presented by this appeal is whether or not Rule 41.01 TRCP in any way affects the time in which a plaintiff can refile after a non-merits dismissal has been taken. We hold that it does not, end quote. That's at page 495. Importantly, the advisory committee to Rule 41 addressed the same issue in 2006, and they said very specifically something relevant to our case, quote, a plaintiff should note that taking a second non-suit, which is permitted by Rule 41.012, does not initiate a second 1-year period for recommencing the action under the saving statute. And that's exactly what's at issue here today. Rule 41.01 permits 2 non-suits, but plaintiffs still must comply with the statute of limitations and the saving statute. Since Rule 41.01 did not extend plaintiff's time under the saving statute, the trial court correctly dismissed the case as untimely. Next, I'll address plaintiff's equitable estoppel argument that is addressed in the briefing. First, the court should not consider plaintiff's equitable estoppel argument because it was never before the trial court and raised for the first time on appeal. In France versus Newman, the court said, errors will not be considered which were not called to the attention of the trial court. So procedurally, the court should reject the new equitable estoppel claim. Turning to that issue substantively, there's no estoppel here because as the trial court found, the parties never entered into any tolling agreement, and plaintiff cites no evidence otherwise. Medtronic filed a motion to dismiss, and the motion to dismiss was based on the pleadings and the issues of judicial notice. Plaintiff's response submitted an email, one that was from Medtronic's in-house counsel to plaintiff's lawyer, offering to toll the statute of limitations to allow the parties to engage in a case assessment process. That was to avoid the cost of litigation and presumably to avoid hiring outside counsel. But that one email did not tell the whole story. And so what the court did is the court stopped the hearing, continued the hearing to a later date, allow the parties to supplement the record if there's any evidence of a tolling agreement. And so plaintiff produced the entire email chain and not just the one email to tell the whole story. And that's in the record at 261 and 265. The emails proved the parties never had an agreement. On June 24th, 2016, Medtronic's in-house counsel sent the plaintiff's counsel an email stating that he had to hire outside counsel at that point and, quote, to avoid any doubt, the offer is withdrawn, end quote. The plaintiff's lawyer acknowledged that with this in stating, quote, I'm sorry we could not work this out, end quote, demonstrating that there was absolutely no agreement on a tolling agreement. And again, there's no actions from the parties that demonstrated a tolling agreement either. The parties never did anything pursuant to any of the terms of the tolling agreement. So by their words and by their actions, there's no evidence of any tolling agreements. Later, when the plaintiff's lawyers dismissed the federal court case and filed their motion, there's no mention of any tolling agreement in that dismissal. The trial judge here gave the plaintiff every opportunity to present any evidence of an agreement, and none was submitted. Where plaintiff does not accept tolling proposals, but waits to file until after the statute of limitation expires, the defendant may raise the statute of limitations as a defense. And that happened in Tennessee Florida Partners versus Shelton. The court affirmed dismissal of a time-barred action where the parties attempted to negotiate, but never actually agreed to a valid and enforceable tolling agreement. Happened again in Sparks versus Metropolitan Government of Nashville and Davidson County. There, just like in this case, the court affirmed dismissal on statute of limitations and rejected an equitable estoppel argument where plaintiff did not accept defendant's proposals. Thus, she could not say she relied to her detriment on the promises in defendant's unaccepted proposals. There's no evidence of any tolling agreement, and that's what the trial court found, and that full record is before this court. Your Honor, this is a straightforward case of the Tennessee savings statute. And based on every argument the plaintiff raised in her brief and what she did today, no matter what the argument, it all leads to one conclusion. This case is barred by the statute of limitations and not saved by the savings statute. Thank you for your time today and request this court affirm the judgment of the trial court.
Thank you. Yes, ma'am, Ms. Conine, you have your time for rebuttal.
Your Honors, the appellee's argument does not take into account the Tennessee Code Annotated 281115, which allows plaintiff time to file in state court after a federal case has been dismissed for lack of subject matter jurisdiction. I would ask the court to review the sua sponte order of the federal court that points out the lack of subject matter jurisdiction over the plaintiff's original federal lawsuit.
Is that a part of the record?
It is, Your Honor.
Okay, thank you. Mhm.
Additionally, in the record is the order of non-suit from the second court case. That is the first case in circuit court. And that is the one where the parties enter into an agreed an agreed non-suit, which says any successor action shall be filed in this court and assigned to the undersigned. That is the same judge that heard the second and the third lawsuits. That language in and of itself contemplates a third lawsuit, the lawsuit which was dismissed, in which dismissal I have appealed to you. The parties and the court in that language contemplated that plaintiff would file again. It is my position that that is when the savings statute began, and from which I had a year to file, and I did refile in that court in front of that judge. I'm asking the court to reverse the circuit court and remand this case for a trial. The point of the statute of limitations, as pointed out in Appellee's brief, is to ensure that evidence is preserved and that fact-finding is not obstructed by the passage of time. The appellee had adequate notice of this lawsuit. The subject matter of the lawsuit has not changed. The parties have not changed. The ability to preserve evidence has not changed from the day the appellant notified appellee to today. There has not been any time wasted on the appellant's part. It was incorrectly filed in federal court. Several months after that dismissal, it was filed in circuit court. After that agreed order of non-suit that contemplated a successor action, a few months later, the most recent circuit court case was filed. I'm asking this court to reverse so that I may have a trial on the merits in the Circuit Court of Davidson County. Thank you, Your Honors.
Thank you, Ms. Conine. To the parties, your case has now been presented to the court. You will receive our opinion and ruling within a due course of time. I want to thank you both for your presentation this afternoon. The lawyers may be excused.
Thank you, Your Honor.
Thank you.
The Honorable Court is now in recess until 2 p.m.
Here. Mhm.